Hello, everyone, and welcome to Uncivil Law. And we do have a case today where someone behaving in an uncivil way. This is from the Sixth Circuit Court of Appeals in the United States of America versus Atrel Howard. In this case, Mr. Howard made death threats against Eric Holder, the former Attorney General of the United States. And he was convicted for these threats because the court judged them to be true threats. So we're going to be looking at the exact language he used and the exact nature of the threats and discussing it in a legal context. And though I feel it's completely unnecessary to qualify this, I'm going to do it anyway just for the sake of it. You know, while I have my political disagreements with Eric Holder, to be sure, I don't want anything negative to happen to him. So, I'm just simply repeating what Mr. Howard did as part of a legal discussion. I, of course, am not making any threats to Mr. Holder. I don't care about him enough to want anything negative to happen about him. He's just not that important in the grand scheme. I have my political differences, but that's political differences. We can be part of a civil society. So let's read the exact language of this and let's get started with this. This will be fun, I'm sure. So this is going to be really, really super positive for my monetization efforts. I just want to note, because I'm going to be reading language that's clearly death threats. So, such is the life of YouTube law. What can you do sometimes, right? On Sunday, November the 12th, 2017, a man identifying himself as Atrel Howard left the following voicemail for Eric Holder at the former Attorney General's law firm, Covington & Burlington, Covington, where Holder is now a partner in Washington, D.C. Mr. Howard said, quote, "Former U.S. Attorney General Eric Holder, I'm going to kill you. My name is former U.S. Attorney General Eric Holder, I'm going to murder you. My name is Atrel Howard. We had spoken in February of 2010. I was a United States unconstitutional convicted prisoner by the Common Pleas Court of Cuyahoga County in the state of Ohio by Judge John Stutela through the second part of the clause of double jeopardy law of the United States Constitution, stating that a man cannot be put twice in jeopardy of loss of life. I mean, a man cannot be put in jeopardy of loss of limb for the same. A man cannot be twice put in jeopardy for loss of limb of the same charge. I started. We have spoken. My name is Atrel Howard of Cleveland, Ohio. If you get this message, you need to realize that I'm under unconstitutional United States law as we speak. I was sentenced to 50 months in federal prison for a conviction of federal offense of beginning, originally, an intentional assault of a federal agent or employee on FBI premises. So I think we're off to a pretty clear start. In trying to determine whether this comprises actual threats, I think everyone's on board with saying, yeah, this comprises actual threats. I'm going to kill you. I'm going to murder you is not exactly what I would constitute ambiguous. And who is the person leaving this call? Well, he identified himself by first name, last name, and city. And he identified himself as a federal prisoner. So, that kind of narrows down the field of people that could potentially be doing this. So, makes the FBI's job that much easier, but let's press on. United States Secret Service Special Agent Philip Hogan testified that during the criminal investigation, he definitively confirmed Howard's identification as the voicemail caller. Hogan made this identification based on his work in a previous unrelated case with which he became familiar with Howard's voice. It's always super encouraging when the police can identify the voice of the person leaving the call. Who is this? Oh, I recognize him from a previous unrelated investigation. I recognize that voice. That's Mr. Howard. So he identified himself, and the special agent said, yep, that's Mr. Howard. I recognize that voice because I've investigated this guy. His voice is burned into my mind. So good times. Great. Carrying on. Upon the government resting of the case, Howard filed a motion of judgment for acquittal pursuant to the criminal rule, which the district court denied. Why would they deny the motion to dismiss? With what evidence could the government possibly convict this guy? Surely they don't have anything like enough evidence. Oh, except for, the actual voicemail and his voice and the testimony. So, yeah. Howard then testified on his own behalf. He denied leaving the voicemail message and insisted he would never threaten the former attorney general in this manner. Howard also claimed that although he and Holder had never met, the former Attorney General did in fact like Howard. Okay, I just like, I like this thing. Because, although it's not stated in the opinion, you got to know that, like, at some point prior, they played the tape, right? During the government's case. And now Howard himself is testifying on the stand. So the jury now can, like, actually hear the guy talk. And if they don't remember his voice, I'm pretty sure as part of impeaching the witness, that's a legal term when you want to contradict the witness, when the witness says, I didn't leave this call, the government might want to challenge that, impeach the witness, and say, okay, well, that's really interesting. Let me just play back this recording. We already heard it once, but let's hear it again. And now let's hear the voice. And, like, that's not you? And he says, no, that's not me. As the jury is thinking to themselves, oh, that's totally the same guy. So, that's just super, super fun. And I do like his claim, although they had never met, the Attorney General liked him anyway. I'm not sure how that's possible. I have also never met the Attorney General. I don't know that the Attorney General likes me. I'm not sure on what basis I could possibly draw that conclusion. So, we've not met. I'm betting he doesn't have a lot of opinion about me. How he could have an opinion about Mr. Howard, only Mr. Howard knows, I suppose. The jury found him guilty. Shocker. And was sentenced to 30 months sentence for the offense and 24-month concurrent sentence for his supervised release violation. So he was already out from the prior conviction, so he wasn't lying about that 50-month thing. So he was already out. So they sent him back to jail for that and for the threats. So, no true threats. We don't like that in law. It's bad. Howard challenges the conviction on 3 grounds. The initial indictment omitted the essential mens rea element based on Supreme Court ruling. The district court plainly erred in its jury instructions when directing the jurors to evaluate Howard's issuing of true threats to Holder based on reasonable person standard, and the government failed to present sufficient evidence to support Howard's conviction for issuing a true threat to Holder under the law. The indictment against Howard for violation of the law satisfies the requirements. The law punishes transmission in interstate commerce of any communication containing any threat to injure a person of another. To convict a person under the law, the government must prove the defendant sent a message in interstate commerce, which, calling from Ohio to Washington, D.C. qualifies. A reasonable observer would view the message as a threat. Yeah, and defendant intended the message as a threat. I'm not... Personally, I'm not finding it really hard to find these 3 elements based on what you've told me so far. Personally, I'm like, okay, is it interstate commerce? Well, the call occurred over state lines. Yeah. Would a reasonable observer view it as a threat? I'm going to kill you. I'm going to murder you. Yeah, probably. The intended as a threat? Well, you used those words, so sure. I as a juror, I'm not having a real hard time finding all 3 of these elements. No. Jan, in answer to your question, if he should have called from the state, if he had... Eric Holder is in Washington, D.C. So if he had placed the call within Washington, D.C., federal law would still be implicated because because Washington, D.C. is a federal enclave. So actually, in this situation, he'd be charged with a different statute, or maybe the same statute because it would have a different provision in it. So it wouldn't be interstate commerce. It would be within the same federal jurisdiction. So he was out of luck in any event if he was trying to avoid federal charges. So no, there's nothing he could do to help himself on this one. Nonetheless, the defendant maintains the indictment is defective because the language does not allege that Howard intended to threaten Holder with a voicemail, but rather that Howard simply left the voicemail knowingly and willingly. This omission, Howard argues, violates the Supreme Court's direction when the court claimed it was insufficient under the statute to have liability turn on whether a reasonable person regards the communication as a threat, regardless of whether the defendant thinks. Howard challenges the following instruction. In evaluating whether the communication contained a, quote, true threat, close quote, you should consider whether the light of the context of a reasonable person would believe the statement was a serious expression of an intention to inflict bodily injury. Howard claims the instruction's reference to a reasonable person contradicts the passage from the Supreme Court, in which the court explained a reasonable person standard is inconsistent with the conventional requirement for criminal conduct, awareness in some wrongdoing. While we agree with Howard that the Supreme Court did conclude mens rea must be read into the violation or to separate wrongful conduct from otherwise innocent conduct, We disagree with the application of the case to the facts at hand. Certainly, the case prohibited a negligence mind state. Scienter means mind state. So negligence mens rea, negligence scienter. We have to use many different fancy words so we can sound fancy. Prohibited a negligence scienter, and incidentally, I don't think I've heard that word since law school, so it's not something that comes up a lot, but nevertheless, prohibited a negligence scienter from supporting a conviction under the statute, holding instead only a mens rea of willfulness or mens rea knowledge will support a conviction. But there was no violation of the Supreme Court's guidance in this case. The district court here complied with the Supreme Court when it instructed as to element 2, given it requested that jurors consider either Howard's purpose of issuing a true threat or his knowledge that the communication would be understood as a true threat. Quoting from the court's instructions. For you to find the defendant guilty of count 1, you must be convinced the government has proved each and every one of the elements beyond a reasonable doubt. A, that the communication was transmitted in interstate commerce. B, that the defendant transmitted the communication either with the purpose of issuing a true threat or with knowledge the communication would be understood as a true threat, that the communication contained a true threat to murder Eric Holder. That's C. A, B, and C I just read to you. Importantly, however, and contrary to Howard's reading of the case, although the Supreme Court rejected reasonable person negligence standard from the statute, the Supreme Court did not alter the framework in which jurors could evaluate the true threat. Therefore, following the Supreme Court's guidance, the elements of the statute's violation should be largely understood in the same way before the decision, with only the addition of defendant's subjective intent requirement in the element. Defendant sent a message in interstate commerce, defendant intended the message as a threat, and a reasonable observer would view the message as a threat. With that in mind, the following instruction provided by the district court was in compliance. In evaluating whether the communication contained a, quote, true threat, close quote, you should consider whether in the light of the context a reasonable person would believe the statement was a serious expression of intention to inflict bodily injury, and whether the statement was made for the purpose of furthering some goal through the use of intimidation. The government does not have to prove the defendant intended to carry out the threat or was even capable of carrying out the threat at the time it was made. The government is not required to prove defendant made the targeted individuals feel threatened or the targeted individual even knew about the threat against him. In fact, rather than conflict with the Supreme Court, the instruction actually contextualized the subjective intent requirement handed down by the Supreme Court. That is because the language likely directed jurors to make pragmatic inferences about the mens rea at the time he was transmitting the voicemail to Holder through the more graspable concept of a reasonable person. For this reason, the jury's instructions were proper and did not contain plain error. So with that out of the way, the Court of Appeals is going to discuss a little bit more about the law as it applies to true threats, because, of course, we have to find true threats for there to be criminal liability. So what makes something a true threat? Let's let the Court of Appeals tell us a little bit more about what constitutes a true threat. Pertinent definitions of threat all revolve around a single theme, an expression of intent to involve a loss or harm. In assessing threats, this circuit has relied upon commonly understood dictionary definitions of the word. Measured by these definitions, the voicemail qualifies objectively as a threat. Indeed, to establish the threat was made, the government needed to do no more than simply play the audible recording that Howard left on the phone. The voicemail begins with this vow made to the former Attorney General: "I'm going to kill you. I'm going to murder you." Howard could not have been any clearer in his threat. You know, I've never had the pleasure of being a defense criminal attorney. Well, that's not 100% true. I did do a few minor traffic cases, but let's not go into that. But anyways, I've never had the pleasure of being a criminal defense attorney. But, you know, this is not like helping as a criminal defense attorney. You know, I'm going to kill you. I'm going to murder you. It's pretty clear. It's like, you know, where did he make a true threat? Well, the time he said, "I'm going to kill you. I'm going to murder you." As a lawyer, I'm like, no further questions? I mean, what am I supposed to do with this? Man. Despite the chilling nature of the voicemail, Howard maintains that he had never met Holder, had no need to threaten him. A reasonable observer would not have understood his message as an objectively serious expression of intent to inflict a loss or harm. We disagree. You know, just because you've never met someone does not mean that you are not posing a threat to them. And we can point to any number of examples of that, including swatting instances, which, you know, where no one has met these people. No one has met these YouTubers and Twitch streamers, and still they're calling SWATs on them for I don't know what reasons, but yeah, the fact that you've never met someone apparently does not preclude you from hating that individual. I'm not sure why, but yeah. So the fact that they've never met, it's like, oh, well, Eric Holder could definitely perceive it as a threat. So yeah, I'm pretty comfortable with this. Considering our prior case, where our court found a threat based on defendant's statement to confidential informant that these guys have to be killed, their buildings need to be burnt down. In reaching the holding, we've determined a reasonable observer eavesdropping on the conversation would have understood the words to be a serious expression of intent to inflict harm. Similarly here, a reasonable person who eavesdropped on the voicemail to the former Attorney General would have perceived the threat to be a serious expression of intent to inflict harm. Yeah, no joke, right? Yeah. Therefore, viewing the evidence in the light most favorable to the prosecution, it was sufficient for a reasonable jury to conclude that Howard communicated an objective threat to murder or kill the former Attorney General. Given a threat involves a defendant's expression of intent to inflict loss or harm, it seems apparent that Howard's declaratory statements, and where he pledges to both murder and kill Eric Holder, both of which preceded his detailed description of injustices inflicted upon him by the Justice Department, implies the requisite mental state under the Supreme Court of either willfully or knowingly issuing a threat to the former Attorney General. Howard argues the evidence of his subjective intent is rebutted by the fact he identified himself on the voicemail prior to threatening Holder, which just falls in the category of a criminal being stupid. You probably shouldn't identify yourself. Not that it would probably preclude the government from figuring out who you are, but still, saying I'm so-and-so and I live in this town, and by the way, I'm a former federal inmate, probably wasn't helping. It made the government's job a lot easier, just saying. And the fact he placed the telephone call all the way from Cleveland, Ohio. But these defenses are irrelevant, given the unmistakable seriousness of the voicemail message. To summarize, we hold that the indictment used to issue to Howard contained all the essential elements required for the government to allege a violation. The district court's true threat jury instruction was not in error, and the government offered sufficient evidence establishing 3 of the elements of the offense, and consequently, we affirm. So that is the end of the case of United States of America versus Atrel Howard. In this case, we learned that Atrel Howard felt that he had been unjustly convicted and unjustly sent to jail. He felt that he had been violated of his constitutional rights as it relates to double jeopardy. Now, I have no idea whether or not that's true, of course. And if it is true, he has methods to deal with that through appeals and so forth and so on. And that's what courts are for. But, one of his available appeal options was not to call the former Attorney General of the United States, Eric Holder, and leave a voicemail message saying, "Hi, my name is Atrel Howard. I live in this place in Ohio, and I'm going to murder you and I'm going to kill you." That was not one of his available appeal options. And as a result of that call, he was sentenced to additional time in jail. So this is an example of true threats. This is an example of illegal behavior. It's pretty simple. Just play the voicemail. We're done. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.